Good morning and welcome to the Law Office of Kyle Watkins. There are two ways to get your felony charge reduced to a misdemeanor, either by force or through negotiations. Force is where the prosecutor does not agree, and negotiations is where the prosecutor does agree. The best examples of force would be the suppression of supportive evidence, such as a confession. The prosecutor may be unwilling to agree to a reduction. However, if the confession is suppressed, that is to say thrown out, the case may become substantially weaker and then lead to an agreed reduction. Likewise, if a material witness makes a change to his or her statement while the case is pending. The ultimate example of reduction by force is going to trial and being found not guilty of the felony offense, but guilty of the more appropriate misdemeanor level offense. Reductions through negotiations come about in a lot of different ways. There are 1,000 different ways to skin the cat to get to a deal for a reduction. The operative question here is not what kinds of deals can we dream up to get to a reduction through negotiations. The question becomes what factors increase or decrease the chances of agreeing to a reduction. If this is your first arrest, it increases your chances of getting to a deal for a reduction. If you have lots of criminal history, the chances of getting to an agreed reduction are decreased. The particular facts of your case also have a lot to do with it. Is the evidence against you weak or strong? Is this a case with a victim, or is this a case with no victim, such as a DWI? The overwhelming majority of reductions from a felony to a misdemeanor occur via negotiations, and moreover are a result of the prosecutor being reasonable. If you are fortunate enough to have a prosecutor with good judgment and the courage to do what she or he believes is right, you are then potentially in a position to strike a deal for a reduction to a misdemeanor. The last factor, your lawyer. The way your lawyer is viewed by the decision makers in the court, the judge, the prosecutor, and the jury, reflects directly on how those decision makers are going to view you. Everything your lawyer says and does not say, all that is done and not done, word choice, tone, inflection, body language, eye contact, rapport, presentation ability, knowledge of the law, trial skill, which would include jury selection, opening statement, examination of witnesses, closing argument, and perhaps most importantly, your lawyer's reputation. All this reflects on you. To put it in a word, persuasion. Is your lawyer persuasive, actually persuasive? A lawyer hiding their inadequacies with a brash attitude of arrogance and a smug demeanor? Or is your lawyer genuinely persuasive, a genuinely persuasive advocate? All of the decision makers involved in your case are people too. And the degree to which those decision makers like, respect, and trust your lawyer will often affect the outcome of your case. Of all the variables referenced in this video, this is the one variable that you can control. If this video was helpful to you, please hit the thumbs up button. It helps push this information out to more people that may benefit from it. And if you are interested in keeping current on criminal law and procedure issues, please hit the subscribe button and get notified when new content is released. See you next time.